Good afternoon. Thank you for joining us again for our live Zoom webinar dealing with the issue concerning child custody disputes and battles part 4. If you're wondering why is it stipulating part 4, there was part 1, 2, and 3. It has been done. You are welcome to view those specific live webinars. It will be available. It is available on YouTube, or you can go to talalaw.co.za/past. You should be able to find it. Otherwise, we're waiting for some participants to join us on Zoom. It will take another minute or two, and we can start the webinar. On the screen, there are a few questions that were posed by our registrants, and I will try my best to answer them. If you are watching this webinar from Facebook Live, these specific questions will be given preference to. However, please feel free to pose whatever questions you have on Facebook Live, and I will try to answer it for you. It has to be on the Advocate Muhammad Abduroaf Facebook page. I cannot see any other pages while I'm streaming this video live. Please head out to that specific page, Advocate Muhammad Abduroaf, the Facebook page. While I'm letting all the participants in on the live Zoom webinar, please feel free to pose whatever questions you may have. I will try my best to answer them. I'll give it 1 more minute, as it is a pre-scheduled live webinar which you had to register for. I think we can begin. Thank you to all the participants who have registered for this live Zoom webinar. I thank you for the questions which you have posed. I see a question on Facebook Live. Yes, you can pose whatever questions you have, and I will definitely get to it today still while this webinar is taking place. And thank you for all the participants on Facebook Live. We have quite a growing population of people watching these videos from all over South Africa, and I can presume other countries as well. This morning I had a webinar with somebody from Saudi Arabia regarding some family issues. And obviously sometimes I get to consult with people, expats, people from the UK, United States. So these videos make its way around the world, and you are welcome to obviously pose whatever questions you may have live. I'll be keeping an eye on the Zoom page, the Zoom registrants. I have to let them in, and at the same time see what additional questions they pose, and at the same time I'll have to keep an eye out on the Facebook page. However, feel free to pose whatever questions you have on the Facebook page, and we can deal with it in that specific fashion. Okay, let us begin. The first question which I have: the father and I have agreed on a parenting plan before our second court date in the children's court. Will this get signed off by the magistrate when we go? The long and the short of it would be yes. The court would obviously have to be convinced that the parenting plan which you and the father of the child have agreed to is in the minor child's best interest. But generally, if the parties have come to an agreement regarding a parenting plan, the court would endorse it. Why must the court really get involved if the parties have resolved the specific issue at hand? So that is the case. The court will generally endorse it. However, if there are any technical issues in relation to the parenting plan which the court wants to deal with based upon previous allegations made in the application or previous allegations made in court, the court will obviously want to first address that. But the long and the short of the matter is, if the parenting plan is fair and both parties are happy with the specific parenting plan, the court will make it an order of court. I think that answers question number 1. If there is any additional questions that you would like to add to that via the Zoom participants, you're welcome to do so. I'm just letting some people in quickly. Just a bit of a word for the people watching from Facebook. This is a live Zoom webinar which you could have registered for free of charge, and your questions would have been sent to me before the webinar takes place, and I'll paste it onto the screen. Many people decide not to pose any questions because they just want to participate or listen in live. At the same time, many people cannot make it on the live Zoom webinar. However, they register, and later on they will receive a link, a YouTube link, where they can watch this video at their convenience. So therefore, I have another few questions. However, if you have any specific questions regarding child custody dispute and battles, part 4, how do I get the best out of my case? The idea basically is you are busy with a child custody matter, a child custody battle, you are dealing with it. However, your question is, I have a specific problem, or this is where this matter is currently at. What can I do? What advice do you have, advocate? Advocate, I am struggling here. What can I do? What advice do you have? Assist me, direct me, guide me. That is the type of questions I want for you to pose. Obviously, you are allowed to ask, and I also do welcome any specific legal questions you have on the process. For example, I live in Cape Town, the mother lives in Johannesburg. Which maintenance court should I go to if the kids are living with the mother? Obviously, the answer would be the Johannesburg maintenance court because the kids are living there with the primary caregiver being the mother. Okay, we have a live question. Let me copy it quickly into our screen. The mouse is giving me a problem here. Okay, that looks okay. Copied it, okay. And let me get it to the screen. So live question number 1. The live question is as follows. Does a 12-year-old have a say with a parenting plan? The Children's Act, and obviously the law, it encourages the participation of children in matters where their lives are relevant, where whatever decisions are being made affects them. It also depends on the maturity of the child. If the child is 3-4 years old, quite young, he can speak or she can speak, but not necessarily matured, then under those circumstances, the court will most probably give them a bit of a hearing, but not necessarily consider what they have to say. However, if the child is most probably, let's say, 12 or 13 years old, and his or her reasons for wanting to reside with one parent are sound reasons, valid reasons, the expert will obviously have to note it, and they can give their opinion on that. But it will not be seen in isolation. It will obviously be considered after consulting with the father, consulting with the mother, and the court will make some type of a decision regarding that. For argument's sake, if the child wants to live with a dad, the child currently lives with a mother, primarily, but the child wants to live with a dad because the dad lives closer to the school, and the child's friends are all closer to the dad's home, and the child is quite old enough, like 16 or 17 years old, to look after himself to a certain extent. And he wants to live with a dad because things are easier for him. He's in matric, or he's going to matric, and it will just make more sense for him. So the court will listen to that specific aspect. And the court might give it a much more weight than the mother and dad fighting over who should look after the child if all else is equal. However, if it's theoretically better for the child to live with the dad, but the dad doesn't have the facilities, the time to look after the child, when the child comes home, nobody will care for him, then under those circumstances, although the child wants to live with the dad, he's pleading to live with dad, but dad cannot care for the child. Or the place is too small, I don't know, but the court might make a decision under those circumstances. Thank you, child, we have listened to what you have to say. However, we think under the circumstances it's best if you remain with mom, although you want to live with dad. Therefore, I hope it answers the question. Does a 12-year-old have a say with a parenting plan? Yes, we have to listen what he or she has to say. However, we have to listen to what all the parties have to say, and then we have to make a decision based upon that. And I'm one of the practitioners who encourages the court or the social worker or the psychologist to find out from the child, get the child's buy-in. That's my new term which I'm using, and I'm developing all these new phrases like toughen up and own your case, and now buy-in. Let the child buy into the system. Let the child know that this decision for you to live with mom or with dad was considering what you want. It's very important that you do that. I hope that answered that specific question. It's a bit hot here in Cape Town. There's another live question before I deal with the other questions as well. Let me try to copy it. This technology is challenging me today. I don't know why. And after this live question, we will deal with one of the registered questions. Okay, this live question says the following. I need to do something here first. There it is. Hi, advocate. May I ask a question? Of course you may, and you are welcome to do so. All of you are. And if so, if a mother takes the children out of the house without my knowledge and moves into an unsuspected new partner's home, what can I do? We did fill in form number 2, but they only gave me a court date without doing anything. There are no allegations other than she is not happy in the marriage anymore. No cases pending. The mother and the father, I'm being general here, and I'm not specifically answering your scenario based upon this. You're giving me a few sentences. I might have missed something. The general way in which I consult with these type of important issues is to ask you 1,000 questions, literally 1,000 questions. And then based upon that, those answers you provide me with, I will advise you on the best course of action. But because the information is limited, I try to be general, but at the same time, take it from a point of view that it might not be correct because you're only giving me that information which you think is relevant. Other information might be relevant as well. If you are concerned that the minor child is being neglected or not being looked well after by the other parent in this new unsuspected new partner's home, you need to have valid concerns, valid reasons for that, to stipulate that. For example, the child is being abused, the child is being neglected, and so on. Then you have a good reason to approach the court urgently, maybe the High Court, and I'll tell the court, these are the circumstances. I want the minor children to remain in my primary care until these issues are being resolved. The marriage has broken down. It's clear to me the parties, one of the parties has moved on, and they never asked your permission, but that's something in the past. It happened. I would expect the party to ask for the permission, and they have not asked for permission, but it's a reality, it's a factual thing, so I cannot dwell over the past. I need to deal with how can I deal with the future. Maybe the kids are well looked after, I do not know. So you need to determine whether or not the kids are being well looked after, and if they're not being well looked after, you need to make a decision. Am I going to step into the situation, be aggressive here, and make an application to court and stipulate to the court that the kids are not well looked after? I can look after these kids very well, and if they are going to be in my care, they will not be neglected, and so on. So that's the basis where I'm going to. The challenge I see with going to the children's court with respect to them the process might be a bit slower than going to the High Court, which is a bit faster. But obviously, the High Court costs more money, it's very expensive, and it's COVID-19, and the courts are very apprehensive and not very willing to assist people like they used to assist people in the past. If you feel that the children are being neglected, maybe get a social worker on board as well. Another consideration. When the kids are with you, have the social worker come over and consult with these specific kids and find out. But if the marriage has broken down and the mother decided to move on and move to somebody else's home, get a new partner and take the kids with her, and the kids are fine, and that is, in my view, the situation. If you have a problem with that situation, you need to show the court that it would be better for the kids to actually be living with you, and you can care after them. You can take care of them much more better than the mother can take care of them. That's the advice I have. You can add any additional information to your question, and I'll be happy to answer that. So you will be the Facebook Live questioner number 2. And I have a comment over here, says, thank you so much, you're welcome. That will be question number 1. You're welcome anytime. Feel free to pose whatever additional questions you have. Let me get back to the second question of the registrants. It goes as follows. I have 3 minor children and their father lost his job recently. I want to approach the court for a court order to claim against his pension fund payout for his kids. Will I be able to apply for it? It's a difficult one because if the father is paying whatever maintenance he must be paying, whatever support he must be paying, and then obviously you shouldn't be able to attach whatever pension fund there is. If the father is not paying maintenance, then obviously there's a reason for attachment. If you are afraid that the father will dissipate the funds, they call it the anti-dissipation order. If you are afraid that the father will spend the funds and use it up and there will not be any maintenance available for the minor children, then you can approach a court and the court can make basically a anti-dissipation order or gagging order, depending what term you want to use, basically ordering the pension fund to pay monies out to the parents, alternatively maybe possibly having a lump sum money being paid to a trust account, and that specific trust account can pay the money out as maintenance. You can be creative over it, but there must be a basis for that. If somebody gets a pension payout, and he is still paying his maintenance, there's no reason for you to obtain such an order. So the court must be convinced that I'm infringing this person's right to use his money. The same way if I get paid a pension fund out and I'm paying my accounts at whatever place it is, they can't now say, no, we want to attach all his money as long as I'm paying my accounts on a monthly basis. Now the same way when it comes to pension fund. There are cases in the past which I've dealt with where the party was in arrears with child maintenance, did not pay child maintenance, does not want to pay child maintenance, and then the court basically attached the pension fund or ordered the pension fund to pay the maintenance on a monthly basis to the parent who is a caregiver of the minor children. So that is possible to happen. My advice to you is go to the maintenance court, speak to them, see what they have to say, and they can make those specific relevant orders. On the live chat, okay, regarding question number 2 says, thank you very much. You are welcome, and you are welcome to pose any additional questions you may have. I'm just going to the Zoom again, letting some people in. Okay, there it is. Every minute or so I have to just double check if anybody's knocking on the door. So continuing with our topic, child custody disputes and battles part 4, how do I get the best out of my case? And I hope that you would possibly benefit from this. Remember, the idea here is not for me to answer specific legal questions like how do I do this or how do I do that. You can go online, you can go on the internet, you can watch my previous videos, and I will most probably answer that for you. I would have answered it for you. However, if you are struggling with a specific aspect regarding your case, regarding your child custody case, the matter might be pending in court, there might be issues, I do not know. Under those specific circumstances, on that basis, please feel free to pose questions. You'll get the best out of this webinar. However, if you have a general question and you do not know the answer, please feel free to pose it in any event. Question number 3. This is one of the pre-registration questions. The father of my child is on drugs. Is it possible that my new husband can be the child's guardian should I pass away? That is a very interesting question. It happens often where I get that question posed, where a client comes to see me for whatever contact rights and so on. Generally, when it comes to relocation or the other party is not much involved in the child's life, or the specific parent remarried and is caring for the child, and that specific parent is now concerned, if something happens to me tomorrow, must the child now be flown down to the other party? Although the other party never cared for the child because the other party is a co-guardian with me. Now, in terms of the Children's Act, if you are the sole guardian of the minor child, let's say there is no other parent, in your will, you can stipulate that at my death, I would like to make my guardian my new husband, my aunt, my uncle, my sister, which happens often, where a sibling gets appointed as a co-guardian, as a guardian in a will. You can do something like that. However, if the other parent is the co-guardian and you pass away, then automatically he or she becomes the sole guardian of the minor child. What I advise people to do under these circumstances, you have one of two options you have. You can either approach the court and have guardianship rights, conferred or appointed to the other party. For example, let's say you've remarried, you're living with your husband, and now the term they use is assignment. And you'll have guardianship rights assigned to your new husband, as opposed to him adopting the child and both of you have guardianship rights over the child. So you have that specific rights assigned to your husband. For the sole reason that, in case there's problems, you cannot be found, and your husband can act as guardian for the child, contractual stuff and so on. But the challenge with that is, I would say, is what if tomorrow you guys divorce, there's problems, and then, we have a situation whereby you divorce and we have somebody who's a third party who is also guardian over the child. Same with adoption. The other party can adopt the child with you, and tomorrow you guys divorce. This adoptive, non-biological parent has rights over the child. And the biological father, let's say that is the case here, he doesn't have any specific rights because he gave off the child. So they can become very complicated. What I advise, and this is my advice which I have for the specific clients. Just 1 second quickly. I hope you can see me. It seems to me my screen has stopped. 1 second, please. I think this is what happens if you're doing a Zoom webinar and so many platforms are on your PC at the same time. Okay, I'll nonetheless continue with my discussion, and hopefully my screen should be able to take care of itself soon. Okay, nonetheless, I'll continue, and hopefully later on we can resolve this issue. So my suggestion to people is, when it comes to that specific scenario, is to inform the other party that the moment you pass away, the moment you're no longer around, that at that specific time, that specific parent makes an application to court, and also court that parental rights and responsibilities can be assigned to that parent. So you do not make an application to court before the time. You make an application to court, you advise a specific relevant party who you want to have parental rights and responsibilities, who you want to care for the minor child. You advise that specific parent or person to make an application at your demise urgently, immediately, for you to be the primary caregiver, or for him to be the guardian holder or primary caregiver of the minor child. To me, that makes more logical sense as opposed to adoption and assignment of guardianship rights while as you are alive. And more than likely, in all honesty, more than likely, you will most probably live until the minor child becomes an adult. And under those circumstances, there was no need for you to have assigned or have the minor child be placed under the guardianship of the other parent or the other person. So I hope that answered that specific question for you. I'll deal with the next question. It goes as follows. What do I do if the mother of my child does not want to agree on a parenting plan? We are now 2 years in court. Now, that is a very common question where people come to me and ask me that specific question as to, we're in court, we're trying to agree upon a parenting plan, but the other party is not willing to agree upon a parenting plan. What can I do? Basically, then you must litigate the matter. You must go to court and let the court make a decision. You cannot force someone to agree upon a parenting plan. That is unfortunately how it is. If someone does not want to agree upon a parenting plan, that is his or her prerogative. And if he or she wants to be difficult and feels that the court will make a different decision, then he or she is welcome to do so. Therefore, if someone is not willing to agree upon a parenting plan, my advice to you is get finality on the issue, come to a point where the other party is not willing to do so, the parenting plan and negotiations cannot be finalized, and under those circumstances, done, let us proceed with going to court and finalize this matter. That's the best advice I have for you. Okay, I have another question, another one of the live questions, the third live question. Let me get to it quickly. And I apologize for the video. I think the Zoom people can see me very well, but the people on Facebook Live cannot see me. So I apologize for that if you are watching this video via Facebook Live. Yeah, the Zoom people are giving me a thumbs up. They can see me perfectly well. It seems to be a streaming issue. I guess it happens if you're dealing with Zoom and Facebook Live and all these specific technologies at the same time. It can cause a bit of challenges. Okay, but let's get to the third question. It goes as follows. Hi, advocate, regarding another matter. A baby was born out of wedlock. One second. There I am back. Nice to be back. Okay, let's get to the third question. Hi, advocate, regarding another matter. A baby was born out of wedlock. The social worker removed the baby from the mother soon after birth. Okay, so parents were married, child was born, the social worker came and removed the baby from the mother soon after the child was born. The father attempted to register the child on his surname but was denied so by the Home Affairs Office, but the mother may. Generally, if the father's name is not mentioned on the birth certificate, then the child will have the mother's surname. But let me go on. Due to the fact that the social worker removed the baby, there is a case open at the local magistrate's court ongoing. Why can the father not register the child that is currently partly in his care with the help of the safe house for the children? Is this process not perhaps against the Constitution, discrimination? Thank you. Of course it is against the Constitution. I mean, a father should have just as much rights over a minor child as the mother. I know they want the mother's consent. If the mother does not give the consent, and obviously there's a dispute between the parents, then one parent cannot just go ahead. It can be a bit complicated because the mother will have to verify and confirm that he is the father of the child, and that is most probably why they want the mother to be the one making the necessary application. Otherwise, tomorrow any woman can fall pregnant, and then she can just say, John, down the road, please come and, accept paternity. All of a sudden, John becomes the father of the child at John's surname, and that's that. Alternatively, John just goes to the Department of Home Affairs and says, I'm the father of that specific child, without the mother confirming it. There we have it. He's the father of a child, although he might not be the actual father of the child. So under those circumstances, I can see there could be possible issues, especially under these specific social welfare issues. you need to go to the Department of Home Affairs and find out exactly what the reason for that is, if it's a logical and a rational reason. I can see the only technical possibility, as I mentioned earlier on, for them denying assistance would be that the mother needs to verify that you are the father of the child. But at the same time, a father can approach the Department of Home Affairs and confirm his paternity, and his details has to be inserted into the registry of birth and death registration register. So that is possible. That can be done at any point. So if on the child's birth certificate it specifically states that there is no father, father is not identified, the father can come to Home Affairs and prove that he is a father, and his details must be inserted into the register. So I hope that sorts that out, and hopefully there won't be any camera issues going forward. And we're running shortly out of time, so I'll deal with the next question. Question number 5 are the people that registered before the time, if you're watching this. I do not have a lawyer. Is it necessary to have a lawyer in High Court? My ex says he will take me to the High Court. I firstly would advise anyone, it is always advisable to make use of legal representation. The same way, when you're building a house, you make use of a builder. When you're dealing with your accounts, you make use of an accountant, and so on. So I will not discount the advantages of making use of legal representation. But regarding the legal question, is it necessary or a requirement in our law that you must make use of a lawyer or a legal practitioner registered with a legal practice council or whatever law is applicable at the specific time? No, you can represent yourself in any legal matter. In the Children's Court, in the High Court, in a civil matter, if somebody sues you for whatever, you can represent yourself. You can sign your own documentation, you can file your own documentation. You do not have to make use of a lawyer. So that's very important to note when it comes to legal proceedings. But at the same time, as I mentioned earlier on, it's always advisable. If you cannot afford a lawyer, then there are other ways of doing it. Watch this video, for example. Then you can, or post questions regarding that. You know, go to the library. Go to a law library. Some universities have law libraries. Most should have it, or all should have it, that offer law. Go to the public library. There might be certain textbooks on the law online. You can Google and stuff like that. Find out information. Go to the court and ask the clerk how the process works, what you can do or what you cannot do, and so on. Then you can represent yourself, and you'll get a better chance of getting a better results as to not knowing anything and going into a matter blindly. So that is my advice on the question: should you have a lawyer? You do not have to have a lawyer. You can represent yourself. And the last question, unless any other questions come through on the Facebook Live. I see no questions on the Zoom, no additional questions on the Zoom. Let us move on. The last question. Question number 6. We are currently separated and married. Can I approach the court for a parenting plan? So the parties are married. No issues regarding that, as opposed to being unmarried and just having a child. So they are married in terms of the law, but they are separated. The question is, can they still approach a court for a parenting plan? Yes, you can. You can approach a court for any relief, even if you are married to the other party. You do not have to be divorced or approach the other party while you are divorced. Therefore, although you are separated, you can approach a children's court if there's a dispute regarding the kids. The law doesn't say you must first get divorced before we can assist you. You can approach a children's court if there's a dispute, and the children's court will obviously have to follow procedures in trying to get the parties to agree upon a parenting plan. If the parties cannot agree upon a parenting plan, and then the normal procedures must be followed. The matter must run its course. For argument's sake, how does it run its course? the applicant will come to court, or the complainant will come to court, and he will say whatever he wants to say to court. The other lawyer, if there's a lawyer the other side, or the other party representing himself, will ask him or her questions, put his or her version to the witness on the witness stand, and then later on, you will come on the witness stand and stipulate your case, and the other party will ask you questions and so on. Then the court will make a decision based upon all the information and evidence before it. Usually there will be an expert report, an expert recommendation, someone who knows about your case, who who made an investigation into your case, and who provided a report on your case. And the court will specifically look at that and make a decision based upon that. I hope that answers your question. You can go to the Children's Court for a parenting plan, even though the parties are still married. What often happens is, and it happens a lot in my profession, parties are separated, they're still married, they have problems, they might divorce, they might not divorce, but one of the parties are concerned that the child will be neglected, or the other party will just come and collect the child or phone the police, whatever the case may be, because there's a dispute. With whom might the child be? Well, the parties are separated. Might the child be with the mother? Might the child be with the father? If there is a pending divorce, there's something called a Rule 43 in the High Court. You can get interim relief. The court can make an interim arrangement, but that can take some time, and the matter might be very urgent. Then under those specific circumstances, the court can make a quick ruling and say, after obviously applying its mind to it, and saying in the interim, the kids must live with the mom or with the dad, or the parties can say, look at here, judge, we are separated, we might be separated forever, we might not want to get divorced, but we need some finality on with who the children should reside with. The court will obviously have to apply its mind and make a decision on the specific issue. And that's it. We had six pre-registered questions, and we had 3 live questions. If you have any additional questions, you are welcome to pose it. We are not running out of time, but usually these type of videos are about 40 to 50 minutes, and I try to keep it under an hour. But if you have any specific question, either from the live Zoom viewers, they seem to be fine, or from the Facebook Live viewers, you are welcome to pose it. Please note that I can only take questions or see questions that are on the Advocate Mohammed Abduroaf Facebook page. Please follow that page if you are interested, and that's a platform I make use of. You might see this video on other specific platforms, like the Our Law platform and a few Facebook groups, but I'm not watching that specific screen while I'm doing these specific webinars. I have a comment from the last person. She says, thank you for your advice, Advocate, much appreciated. You are welcome, and thank you for your question. That's also very much appreciated. If there's nothing else, thank you everybody. We have reached the 40 minutes time for the specific webinar. If there is any other questions, I'll be happy to answer it. Otherwise, I hope you have a lovely day further, and thank you for registering for the specific webinar. Thank you for your questions, and thank you to the live Facebook viewers for posing those specific questions. And the more you pose these questions, you're posing questions that other people can benefit from. So I'm answering your question, I'm applying the law to your specific circumstances, but there might be a few thousand people out there that have has exactly the same specific question, or the same answer, sorry, the same problem. And by watching these videos and with you participating, we're giving everybody an opportunity to learn and benefit from that. Please share this video if you liked it, and hope to see you next time. Thank you. Bye-bye. Good morning. Welcome back. I hope you're having a wonderful day. We're following up from yesterday's webinar on child custody and child maintenance. We are taking live questions from you on the Advocate Mohammed Abduroaf Facebook page. Take a minute to get yourself ready. This webinar should start in a few moments' time. I'm just giving everyone an opportunity to join us. We have published the webinar for 9:30 a.m. There was a change in times, I trust we all receive the notification on time. I'm just sharing it to relevant pages. Please note, if you have a question, you need to post it onto the Advocate Mohammed Abduroaf Facebook page. That's where the live stream is originating from. I think we're all set. Let us begin. Again, a good morning to all of you who are joining us on today's Facebook Live Q&A on the topic of child custody and child maintenance. We're following up from yesterday's webinar that took place early morning, whereby you could have posted live questions. I have a comment. Yes, good morning. Thank you for that. And someone from the Northwest, all welcome to join us. As mentioned early on, you all are welcome to pose live questions, and I'm hoping to go straight into that. Therefore, if you have a question regarding child custody or child maintenance, the other party is refusing you contact to your minor child, or there are difficulties in relation to the exercising of your parental rights and responsibilities in relation to your minor child. Alternatively, if there is an issue regarding child maintenance, feel free to pose your question. Another good morning. Thank you very much for joining us. It's always nice to know who is joining us, and please mention, if you do not want to pose a question, feel free to say hi or to post where you are streaming from or viewing this video from. It is a live video. It does get posted onto YouTube later on, and it will remain on Facebook for some time. If you are watching this video but not live, it will be senseless to pose any questions. However, if you are watching it live now, feel free to pose whatever questions. We are still in the midst of the lockdown. Things are different. I had a webinar yesterday with an attorney, and we discussed these issues, and it was clear that in 2020 last year, parents got used to the idea of lockdown, and contact arrangements had to be amended. The specific contact arrangements that were in place previous to the lockdown, prior to the lockdown, whereby maybe it's stipulated that the minor child will spend half the school holidays with one parent and the other half with the other parent. Contact will change on Christmas Day. Doesn't apply now because school holidays are much longer, and it gets extended. It got extended now recently for another 2 weeks or longer. Therefore, things are totally different than they were before the lockdown. And therefore, with that, the challenges are different. Regarding child maintenance, things are more expensive. Kids eat more while they're at home. They use more water, they use more electricity, they use more data, whatever the case may be, whatever your circumstances are. They may want to visit friends more often. They may want to phone friends more often, whatever the case may be. The expenses are much more. If they are at school, obviously, they can run up the school's bill with the toilet bill and the electricity bill and so on. But if they're at home all the time, things are different. It might not be. Sometimes it's cheaper. There might be other changes. For example, your transport bills are a bit less because you are not traveling that much. So it varies. However, each family is different. I have a question. I have a live question from someone. I'll answer it now. All is looking in order. The question goes as follows. Last year, I only saw my son for only 6 days due to COVID-19. We live in different provinces. Do I have a right to catch up on lost time? The principle of catching up on lost time doesn't really apply if there is a court order by default. So if there's a court order in place stipulating that you should have contact X, Y, and Z, and you do not have contact in terms of that court order, it's not for the parties now to, if they can on their own agree upon it, wonderful, but it's not for one party to say, okay, I want to now catch up by now having more contact at that specific date, and the other party must automatically agree there too. It is unfortunate. Therefore, when these type of things do happen, the parties need to go to a mediator or facilitator to resolve it. Practical and reasonable parents would take note of the fact that contact was limited during the lockdown and due to the COVID-19 pandemic, and allow a parent to make up that specific lost time, because the person or the individuals that loses out under these circumstances are the minor children. The minor child wants to have contact with the dad. He could not have contact with the dad because of the lockdown. They live in different provinces. We all know for the first few months, interprovincial traveling was not allowed, and the parents has to be reasonable. However, on the flip side, for me to stipulate that automatically you have a legal right to or request, and the request must be abided by, I need to have more time with my minor children, despite an order stipulating you only allowed to have contact on that specific period of time, is very difficult for me to say. I cannot say that because there's an order in place. The order might say the father can have contact every June holidays for the second half, but he was not allowed to travel to Cape Town or to Johannesburg during the second half of the June holidays because of the government's regulations. For the parties now to swing the order to allow a deviation of the order can be problematic on both sides, because a mother might have made arrangements for the kids might have to be in school, the kids might have certain other plans planned for the balance of the period whereby they should not be in the other parent's care or contact. So it's very unfortunate that parents cannot agree upon it. My advice to the specific person is stick to the court order, and if the other party does not want to allow you additional contact for no good reason, then I would strongly advise you to approach the court, and the court can relook the whole issue, and the court can amend the contact and care arrangement. For the sole reason, as I mentioned earlier on, contact and care is a right of the minor child, not necessarily the right of the parents. Yes, parents need to see the minor kids as well, but if it is not in the minor child's best interest to have contact with a relevant parent, that specific contact should not happen. I hope I answered the question. I must just be very cautious, because if I had to now say, yes, catch-up is allowed, when will catch-up take place? During school term, parents are living in different provinces. So I'm being very cautious in that answer. I'm certain if you want to add additional questions to that, I might be able to elaborate further, depending upon the age of the minor children, how far the provinces are apart, are the parents working, are the kids attending homeschool, are they, we all know they're at home now, but the facts will vary. In order for me to give a proper answer, I need to know more facts. Thank you for that question, and you're welcome to pose any further questions. If you are watching this video, please leave a comment and say from where you're from, and it's always good to see regular faces online. If I may just add further, okay, the person poses additional information. Let us deal with that first before we move on. The additional information, sorry, it's a different person. I have another question. Unmarried father who does not have visitation rights and is behind on maintenance and always has excuses, not working, can't afford, or in debt. That's what the person is saying. So he's behind in maintenance, always has excuses, blah, 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 and he is in arrears. Child is a non-verbal special needs child. Yesterday, he brought my son to court as he was visiting him. Court and his lawyer was not happy. Now my case is postponed till March. And when I asked him to go buy food for our son, he threatens me with the welfare. Can you advise? I do not follow the stream so well, but be that as it may, this is a typical example where parents cannot come to an agreement regarding what's in the best interest of the minor child. We want parents might not be much involved in the minor child, and I'm presuming it's generally a scenario where the parties themselves have issues, and that is very unfortunate. My experience under these type of matters are that the moment parents have issues, they can't communicate with each other, they have difficulties with the manner in which the other parent is caring for the child, difficulties in the manner in which the other parents are dedicated to the well-being of the child, and so on. These type of issues keeps bringing problems to the situation. Like now, when the person said over here, child is a non-verbal special need child, which is very important to note. Yesterday, he brought my son to court as he was visiting him. Court and his lawyer was not happy. Now my case is postponed. I do not see the logic behind bringing a child to court. It's COVID-19, and why would the child come to court in the first place? There's no reason for it unless the court requests the child to come to court, either for an assessment or for some consultation with a court official or a social worker and so on. So these are serious issues over here. And with the mother mentioned here that I asked him to go buy food for our son, he threatens me with welfare. Can you advise? Now, the relationship between a mother and father is obviously toxic, and I'm not, this is only facts here, it might not be correct, I'm not referring to anybody. I was given a set of facts, a set of questions, and I need to apply my mind to that. It's clearly toxic. It seems to me on all fronts, when it comes to the parenting of the minor child, specifically stipulates over here, the person starts with a sentence, unmarried father who does not have visitation rights and behind on maintenance. But later on in the paragraph, he said the father brought the minor child to the children's court or to the relevant court over there. But be that as it may, the relationship between the mother and father is clearly toxic. These type of matters will always be there. They will always have these type of problems. So my strong advice to these specific persons are, have this court litigation finalized as soon as possible. Get an order in place. If the order says that the father can have contact X, Y, and Z, and that's it. Or it says he cannot have contact, whatever the case may be. If the maintenance order stipulates that the father should pay 100 Rand or 200 Rand, have it finalized. If tomorrow the father can afford more money, and you believe he can, then you approach a maintenance court again. But the more the parents communicate with each other, and the more the parents start dealing with each other, especially under these circumstances, where the mother asks for maintenance and then the father threatens to take the child to welfare. I would imagine maybe to social services. I do not know what that specific means. It could also mean maybe apply for SASSA grant, could be anything. But be that as it may, unless these specific parents figure out a way to communicate with each other civilly and responsibly and so on, the minor child will always be in the middle, and the minor child will always be affected by how these specific parents respond and deal with these situations. So my advice to the specific person is, I do not have this one-step advice to fix these type of problems, or do this or do that. I would most probably have advised you at the start, go to the children's court or go to the maintenance court, but you are there. My advice is, finalize those issues and come to a resolution as soon as possible. Okay, the question regarding the interprovincial traveling, an additional comment. He says, thank you, you are welcome, and he lives in George. Yeah, so George is quite far away, and I strongly believe that the parents need to come to some type of a resolution. And with COVID-19 being indefinite, there will have to be a change in the manner in which parenting plans and consent papers are drafted going forward. Consent papers and parenting plans, settlement agreements, dealing with the minor children, of course, in the past presumed that school holidays will always take place June, July, December, January. I'm talking about the big holidays. And of course, Easter and other holidays as well. Now with this pandemic, we're seeing it more often that holiday contact is not always set in stone. School holidays are no longer the same duration they were in the past. And they swap and change, they change all the time. The only advantage I can see for me is traffic is much better to work, which I appreciate. But kids are at home and they should be at school. They should be learning to become professionals in the future. But be that as it may, parenting plans, consent papers, and settlement agreements regarding to minor children, clauses will have to be created to deal with these specific issues, the pandemics. Therefore, in additional response to the question posed early on regarding the interprovincial contact taking place, in the future, the courts might have to put in clauses, for example, saying if there is a pandemic and if the minor child is not possible for the parent to have contact with the minor child, then under those circumstances, contact should be extended by the time lost. Those specific clauses will have to be created. It was not previously stipulated generally in consent papers because things were usually set in stone. The minor child is in primary school now, and next year will be in high school. The minor child is in daycare now, but in a few years' time, he or she will be attending school. So those things were basically set in stone, but now we do not know how the future will unfold. A lot of questions are coming in. Thank you very much for that. The maintenance issue, the person commented further, says, X makes everything about me. No request was made. X is very abusive to me. I give him access as I want peace. This is my advice to anyone. If another person is abusive towards you, committing domestic violence, emotional abuse, psychological abuse, whatever the case may be, I strongly advise that you enforce your rights and you obtain a protection order. A protection order, approach a domestic violence court in your area. If there has been, say that he or she is not allowed to commit a psychological or emotional abuse, and if he or she does do that again, we go to the police station, the courts will provide you, on a successful application, with a warrant of arrest, and the police will arrest this person for violation of the protection order. Something to consider, something to look up. There's many articles on the internet dealing with protection orders. It's concerning, and it's a reality that when spouses meet each other, things are fine, they have a child, and life is good. When they separate, things become toxic. Not all situations, but when it does become toxic, people have one mission. It is to make life hard for the other party, or the mission might just be, only to not listen to the other party and be one-track mind, only focus on what's best for them and what will work for them. That's very sad. And if that is a situation, I always advise people go to mediation, go to facilitation, speak to a parenting counselor or childcare counselor, someone that deals with these type of matters, who can speak to the mother and the father. Mother can speak and say, I have the following problems with the dad. These are the issues I have. I've been having these issues for the last year or two. He doesn't want to listen. Fine. But he's in the room, so he's listening to her. He never listened to her for the last 5 years. And then he'll speak as well, and he'll give his response for why he's responding that way, why he's doing that, what problems he has with the mother. And then she will have a chance to reply and so on, depending upon how the facilitator or the social worker or mediator decides to deal with this matter. The parties will now come to a conclusion, and they will most probably leave that meeting or that session at least with some additional data on their hard drives. Where previously it was only there while you're thinking, but now they actually listen to the other party's reasoning and logic. And the other party can say, when the child is here, the child is angry, the child is, depressed, anxious, and so on. The other party initially might be angry because how can you say that the child is not angry and and depressed when he's with me. But she said it. Initially, his response or her response might be a bit not what we'd want it to be, but he or she will go home and it will settle down and he will start pondering on that. So dialogue is extremely important. The person comments further and says, I have tried to be peaceful, but he constantly attacks me. I would say a protection order. If you have any questions, please feel free to pose it. I do not mind speaking for a long time, for the entire 40 minutes, but it is always beneficial to you to pose your questions and have someone answer it and we can engage with each other. I'm just figuring out, yes, the person that commented earlier on regarding the interprovincial contact rights, wanting to know, can there be any catch-up contact rights? He has an additional comment. He says, if maintenance is increased and all of a sudden life quality is increased of the mother, he is done for over 1,000, etc., what can I do? Regarding that, if you are paying maintenance, maintenance is payable for the minor child or minor kids, depending upon the facts. Maintenance is not there to support the other parent. If you are supporting the other parent, it will usually be in terms of alimony, in terms of a personal maintenance clause in a divorce agreement, and so on. Then you have a legal obligation to maintain the other parent, pay your alimony, pay your personal maintenance. But if there is no such agreement in place or no such order in place, there is no obligation for you to maintain another adult. The only time you have to maintain another adult if you are married to that person or in terms of an order and so on. Therefore, if a party is increasing the payment of maintenance, that specific maintenance has to go to the minor child. If it is not going to the minor child, obviously there needs to be a reduction. If the mother is increasing her lifestyle, there could be many reasons for that. One reason could be she's earning more money, she got some money this time, she inherited money, whatever the case may be. The calculation in determining what amount of maintenance you should pay is based upon 3 factors. Firstly, the cost of the minor child. That's important. What are the reasonable costs of the minor child? That's a base from which we work. If the minor child only cost 100 Rand a month, you cannot claim 200 Rand a month. That doesn't make logical sense. If the minor child cost 50 Rand a month, but both parents earn 50 Rand per month, that's a problem. We have to lower the minor child's expenditure. If the minor child costs 100 Rand a month, the father earns 1,000 Rand a month, and the mother earns 2,000 Rand a month. Clearly, the mother should pay 2/3 of the minor child's expenditure, and the father should pay 1/3. So the mother pays 63 Rand or 67 Rand, and the father will pay 33 Rand. That's the basis upon which we decide maintenance. The needs of the minor child, the means and expenditure of the mother, and the means and expenditure of the father. Now, when we determine means, we have to look at various aspects. Someone may be unemployed, but he or she has a pension fund, he or she has property, gold coins, assets laying somewhere. So he has means, or she has means, although he or she does not have any income. Therefore, when determining a fair amount of maintenance a party should contribute to his or her child, we do not only look at the income, we look at the means. Because it will be a bit unfair if the mother, in this example, in my example at least, has to use all her money to maintain this minor child, and the father earns much more money, and he uses a lot of his money for investment purposes and is developing himself. And the proportion upon which they worked it out was based upon income only, but the father is a multimillionaire, he earns properties, etc. So it's important to determine the maintenance amount based upon the minor child's needs, the means and expenditure of the parents, and so on. Going back to the question, I cannot comment as to whether or not the mother upping her lifestyle is reasonable or not. If the mother has increased her income, things will have to be re-looked at. So when the maintenance agreement or the maintenance order was made, the mother earned X and the father earned X, and the father had to pay X. I'm presuming the father has to pay. Now the mother's income has increased drastically, or means has increased drastically. Clearly, there needs to be a recalculation whereby the father would have to pay much less. My advice to the specific person is, you need to determine, is the mother using the money which you pay towards a minor child, or is she supplementing, that's the word, supplementing her lifestyle with the maintenance you are paying. Alternatively, she may be paying or using that maintenance which you are paying towards a minor child, but your contribution which you are paying is far too high based upon the means of the mother. In other words, she's earning much more than you, she has much more assets than you, she should be paying more towards a minor child than you. Something to consider, something to look at. It's only 2 sentences. I cannot conclude specifically in saying this applies to your scenario. I'm giving general advice, and it might apply to you, or you can use that to take it further. The question regarding early on the maintenance issue, where the parties are embroiled in some type of misunderstandings and the father is emotionally and psychologically abusing the mother, the person says, thank you, you are welcome. If there are any other questions, please feel free to post it. I'll be happy to answer it. Yes, we're heading for half an hour. These videos are usually 40 minutes or so. And if you have any additional questions, wherever you are, please feel free to post it. I'll be happy to answer it. And as mentioned early on, please pose a question from the, you can see over here, Advocate Mohammed Abduroaf Facebook page. Go on Facebook, type in Advocate Mohammed Abduroaf, and you should be able to find the page. If not, that's the URL for the page. And that's where I'm looking at all the time and waiting for questions to come in. The format of these webinars is not to mention the law. We all know the law. You can download the Maintenance Act. You can read the Maintenance Act, and there's the law. You can look at the Constitution. You can download the Children's Act, and that's the law. The idea behind these webinars is to explain to you basically on how the law works, the practical aspects thereof. It gives the viewer and the listener a much better understanding of how to resolve a legal problem. It's like if somebody is sick and I give him a medical textbook, that won't fix the problem. I need to, medicate him. I need to do what I have to do in order to make him feel better. And the same way with these webinars are to unpack and to explain to you on how to deal with these, whether your specific maintenance or child custody matters. While I'm waiting for questions to come in, please note that, like the Advocate Mohammed Abduroaf page, notifications of webinars are now posted there on. If there's a change in times, you will see it online. So you can just go online all the time. Alternatively, you might see it on your Facebook profile. On the issue concerning child maintenance, and this, I'm just following up on this webinar I had with this attorney yesterday, whereby we touched a bit on child maintenance, and her view, and I agree with her, as an attorney, it's up to the parties to buy in, and they need to make an effort for their maintenance case. Me as an advocate, as a litigator, someone that appears in court, I do not generally deal with clients filling documentation, finding documentation, and so on. That's generally attorney's work. But I have said it previously in my webinars quite a few times that you need to take ownership of your case. Yes, the other party is not paying child maintenance. Yes, the other party is emotionally and psychologically abusing you. You can have the victim approach. Unfortunately, I'm being very cold here. And hope people will still feel sorry for you and hope that the world will change and you will get the results you want. Unfortunately, that's not how the legal system works. The legal system is quite cold, very analog, very logical, and there's no room for emotions. If you go to court, so the same principle applies. And also with the maintenance courts, they're quite busy, they're understaffed. You only one of the thousands of cases that are before them. You're just another person coming to them. And if they have to deal with 100 cases per day, you only have 5 or 6 minutes for argument's sake. I'm just exaggerating here. Therefore, in any legal matter you are dealing with, being a child custody, child maintenance, a traffic fine, you need to take ownership of your case. You need to do the relevant, work in order for you to get your results. Yes, you can appoint an attorney, you can appoint an advocate. He or she will do what he or she has to do to get you the best results. However, it's very much dependent upon you. The same with losing weight. You can have the best personal trainer. If you're not willing to put in the effort of eating well and exercising regularly, you will not get the results you want, no matter how good your personal trainer is. The same with the law. Therefore, when you apply for child maintenance at the maintenance court, prepare your documents. Highlight the relevant documentation. Make the photocopies. Don't let your attorney do all those type of things. Why can't you do that? Go to the maintenance court and file your application. Stand in a queue. Why must you pay a lawyer to do that if you can do that? That's all that I have to say now. We have another question that came in. Thank you for that. It goes as follows. My kid's father is no longer interested in being in her life. I haven't asked him for financial assistance ever. He has last given me in 2019. Is he liable to assist me with medical aid and school fees, etc.? Bearing in mind he doesn't support financially at all and doesn't choose to see her. I would presume, and the person can tell me if I'm right or wrong, that there is no maintenance order in place and the parties have some type of informal understanding or arrangement which seems not to be working. But if there is a maintenance order in place, please comment upon that and I can change my answer. But I will answer now based upon the assumption there is no maintenance order in place. So it starts with the following. My kid's father is no longer interested in being in her life. That is very unfortunate and very sad because this child would like to know I have a father. I see my father regularly. My mom and my dad are no longer together, but I still have a dad, and he might have remarried, he might have moved on with his life, but there's a dad in the picture. I see once a week, once a month, whatever the case may be. But I find it a bit, disconcerting that a father does not want to be in his or her child's life. There could be many reasons for that. I do not know. Maybe the couple themselves have certain issues, and if he might feel that because I have issues with the other parent, whenever I want to have contact with a minor child, I have to engage with that parent. That could be one reason, but I don't think that's a valid reason. I mean, you need to go beyond that. People are in court all the time fighting for their rights to see the minor kids, despite the issues involved. So that's not a very good reason, but that could be the reason. Alternatively, he or she is apathetic and does not want to see the other child. I think that's very selfish. And I feel very sorry for that child. And I pity the parent that is like that. The person commented further, my facts are correct, there is no maintenance order in place. So the parent goes further, or the person goes further and says, I haven't asked him for financial assistance ever. He has last given in 2019, so that's about almost 2 years ago, depending upon when. Is he liable to assist with medical aid and school fees, etc.? Yes, he is liable to assist. He is a biological father. He is even liable towards you for maintenance since the party separated or since the last time previously when he last supported a minor child or when last you lived together and so on. In terms of the Maintenance Act, you can claim from birth. But be that as it may, you are entitled to claim from him costs for medical expenditure, school fees, and so on. And the person goes further and says, bearing in mind he doesn't support financially at all and doesn't choose to see her. My advice to the specific person who made this comment would be approach a maintenance court as soon as possible. Many parents are apprehensive. They hear from friends or from family, you won't get what you're entitled to in a maintenance court. It's a waste of time. I do not think so. I would say, yes, under certain circumstances, things can be a waste of time because the other party does not have any money. The other party is unable to, to support a minor child, whatever the case may be. It's like me telling you, don't apply for a job ever, because when you apply for a job, you will not get a job. Because all my friends, they applied for jobs and they never got jobs. That's not good logic. Yes, you apply. Sometimes the results are good, sometimes the results are bad. But at some point, you should get the results. Millions of people have jobs. Okay, so moving on. You need to approach the maintenance court as soon as possible. The maintenance court would call him in. They will call you in. They will inquire into the matter. You will obviously explain to the maintenance court how much the minor child costs, come with the documentation, receipts, proof of expenditure, working out very well that the child eats so much, the electricity, water, etc. And there's many webinars, videos online dealing with that and how to calculate the child maintenance. Just Google it. And you will come prepared and he will say, this is a father and I have information regarding that. He used to work here, he used to work there. I went on Facebook and I see he has a very good social profile. I have spoken to his family and they told me the following. Okay, that might be hearsay. These are the places he lost work at and I spoke to him and he's earning so much money. Do a bit of research. I'm just being general here. I mean, I do not know all the facts. I need to sit down with this file and be creative and get some, creative juices out there to find out how to deal with such a matter. But be that as it may, go to the maintenance courts. Let the maintenance courts deal with him. And the more effort you put into your case, the better the results. The specific person provided some additional information. I've never kept him away from her. He is remarried for the past 5 years. He has been in and out of her life. So I presume the parties were married before when she says remarried. He stays away and comes back like nothing happens. I'm 100% certain he will come back. I'm just scared that it will cause us psychological issues in the end. You see, this is the reason why I suggest parents, the moment they start having these type of issues, these parental issues, you need to legalize and formalize things. In the sense of getting a parenting plan in place, getting some type of an agreement in place so that you know that I will only have to see this person X, Y, and Z. I cannot unfortunately change people's personality. The specific father, that is his personality. He might be a wonderful person outside, but when it comes to his family and when it comes to his ex-wife, there are issues involved. It could be because he remarried, his new wife, he has new kids, and this is a previous relationship, whatever the facts may be. However, the psychological harm which a minor child suffers, well, of course, it's bad. Therefore, we need to take stock of these type of matters. If he's not paying maintenance, go to the maintenance court, because maybe the mother's view is, and I'm speaking general, I'm not saying specifically the specific person, could be, if I claim maintenance from him, then he wants to be in a child's life, so let me not do that. But at the same time, it's a problem because we need the maintenance. Furthermore, we have no contact agreement in place. We need to formalize these things. If parties were not married civilly, civil marriage are simple. If you marry somebody in court, you get divorced, you get divorced, the court will deal with the parental rights and responsibilities. If people are in a relationship or married in terms of Muslim rights and so on, there is no divorce court dealing with these type of things, contact and care rights and child maintenance. Therefore, I strongly urge this person to formalize the arrangements. If he should see the child once a year on special days, then that's it. Then you know he cannot come on the other days. And you can control and deal with your life. When he gets called into the courtroom, or before the magistrate or the officer, depending upon the situation, you will have to explain, what does he want? Does he want to have contact? When does he want to have contact? And so on. The conversation will take place. But the two people who are the worst to have this conversation together would be the mother and the father, because they cannot see eye to eye. It's clear. If they could see eye to eye, we would not have had this discussion. Therefore, I'm not specifically answering, or my facts might be totally incorrect. I'm not judging anybody based upon 2 paragraphs. I might be totally off, I might be totally wrong, and I apologize for that. I'm just taking information and I'm giving a general answer. It might apply to the commenter, it might apply to you watching this webinar from wherever you are and whenever you're watching it. Please, my advice to you is formalize matters, finalize matters. I don't know how old the child is. The child might be 10, 15, or 13. Whatever the case may be, formalize it, go to the maintenance court, get the maintenance order in place. Go to the children's court and formalize the contact and care arrangements. At least you will know he cannot pop up anytime. He can only pop up in terms of this agreement. And if it does not pop up is a bad term, but if he does not exercise his visitation rights in terms of the parenting plan or the order made by the court, and then you approach the court again, tell the court this is nonsense. He does not adhere to the court order, therefore take that clause out and find out by him when does he want to have contact, maybe once a year now. Or he can only have contact once a year, but he needs to check with the mother at least 3 months in advance, or 2 months in advance, or 2 weeks in advance. I don't know, whatever's fair and reasonable. You'll have to argue it before the magistrate. Oh, the person said true. So I hope I answered, or I dealt with that specific question reasonably, so that it makes sense. But at the same time, the viewer and someone else, I hope you understand what I said and can benefit from that. If you have any additional questions, I can still go for another 8 or 10 minutes. It's now 42 minutes we are live. Please feel free to pose the question, and I will try my best to answer it. If you have any additional points to add to the previous questions, I'll be happy to deal with that. So going back to my discussion I had earlier on with you regarding a maintenance matter, in any matter, take ownership of that. I like it when a client comes to my office and tells me, yes, Mr. Abduroaf, I have child custody issues. I have prepared a historical data, or typed out this history of my matter. I have on paper when I met the other party, how things were then, when we entered into a relationship, for example, either marriage, or when you started dating, or when you started moving in together. I have outlined when the problem started happening then, when the child was born, who was at the birth, what were the complications involved, and so on. And I have that on data. So before you even go to a lawyer, you need to take stock of your case. Yes, of course, you can consult with a lawyer, obviously, for advice at any time. But I would strongly advise someone, if you do take stock of your case, you have these things in place. Why should you first sit with an attorney or an advocate, and then the attorney advocate takes notes? Okay, ma'am, when were you married? What were the problems? And bill you thousands of rands for the time spent. Yes, it was urgent, and those are the facts, then wonderful, life must go on, and we need to deal with what we have to. But if you are having problems with the other party, and you foresee the possibility of these issues going to court one day, take pen and paper, go on your PC, go on your computer, archive this time. If there are any episodes of your partner attacking you, or acting irrationally, or acting irresponsibly towards a minor child, it might not be a big thing. It might just be a once-off thing, and it could have been one to allow it.